What do you do if you don't know where to send your student loan referrals and you don't want to do them yourself? This is what this video is about.
You're watching 720 System Strategies, the #1 YouTube channel for bankruptcy attorneys.
Student loan referral system for bankruptcy attorneys. That's the purpose of this call, and that's why we're all here today. And thank you for joining. I want to take us back to 18 months, 24 months before Biden released the attestation on student loans and how to discharge student loans with that attestation through bankruptcy, right? Ken Neely was actually our first bankruptcy attorney in 7 steps to 720 credit score, called me up. And he's always an innovator. Like this guy, for those that know Ken, he's someone who innovates constantly in his bankruptcy practice and life. I've known him for many, many years. And he says, Phil, I'm going to start discharging student loans through bankruptcy. He was doing it under Bruner. And I was like, wow, that's exciting. Will it work? He's like, well, we're going to figure it out. I'm going to try a bunch of cases. And this is before the guidance, before the clarity, before any of that, right? And the years went by and it started working, and he started getting discharges, $20,000, $50,000, $100,000 of student loans gone through the bankruptcy under Bruner. Then the guidance came out. Oh, and by the way, I want to point something out. He did it not only with private student loans, but with public student loans as well, right? He did all types of student loans. It wasn't limited in any capacity. He just rolled with it as he rolled with it. Then the guidance came out. And when the guidance came out, if you recall what the guidance said, here's the attestation form, and this will only work for bankruptcies. I believe it said filed as of this date, or maybe it was discharged as of this date. I don't remember. But Ken, once again, was like, no, I've been doing this forever. No, I'm going back to my past clients. This will still work. And the guidance didn't change anything. It just validated what Ken was talking about, right? And when that happened, I remember thinking how excited I was. I remember talking to Ken, oh my God, this is extraordinary. The wave of what's happening. We spent months and months testing ads on how to get this message out. We realized with the ads, when you put out these ads, you would put out ads, but people just wouldn't believe it. Like there was a big, big breakdown. It's like, no, I was told I could never discharge student loans. No, it can't work. They felt there was like a scam component, right? And there's other components that cause breakdown where, the NSLDS file had to be downloaded by the debtor, not the attorney. There's all these hurdles that were hard to do. But when we were running ads, it was unbelievable. I mean, at one point we transferred Ken 110 live transfers. These are people we qualified and transferred live. 60 retained as firm, and 51 of them needed a bankruptcy. Okay, so they didn't just need a student loan attestation, but they needed a bankruptcy and a student loan. Think about that pricing. You're not just charging for the bankruptcy, you're charging for the student loan as well. And I remember at that point thinking, this is the wave. Like we've been waiting so long. We went through COVID and we went through this frustration. Like this is the wave of bankruptcy. And like nothing happened. Right? I remember talking to Igor, who I mentioned, I spoke to Igor from Stretto, and I'm like, hey, when's the wave coming? Oh, it's coming. We built software for it. Spoke to Josh Cohen, student loan lawyer. Okay, who's jumping on the bandwagon here? Like, what's going on? And as long as we waited, it just kept on. Like, no one was really adopting it. Like there would be random adoptions, but it just didn't like flood the market like I thought. I believe Igor thought, I believe Josh thought, and a lot of us really thought that this was going to be just this game changer, right? So I've thought a lot about this. I've talked to Igor about this. I've talked to Josh Cohen about this. I've talked to people about this. Like, why are not people adopting it? And what I've come to believe in my heart is that it's another thing to learn, right? It's like it's a little bit outside of bankruptcy because it's on the litigation side, even though it's a form. It's on the litigation side of the law, and it's another thing to learn. And I'm busy with bankruptcy. Like I got bankruptcy calls going in like crazy. I don't want to be distracted. How do I price it? How do I charge for it? You know, how do I bring it up to the client? It's not natural, right? And I just was sort of like resigned to, okay, well, this is the way it is, and we're moving on, right? We're going to focus on bankruptcy. If my client base wants to focus on bankruptcy, that's what I'm going to do. And then about 3 months ago, Ed Bolt, who many of you know, the former president of NACPA, called me up and said, "Hey, can you host like a call on student loan pricing?" And I was like, "Sure, sure, I'd love to." So I put together a group of people, 6, 8 people on the call, I think. Maybe there were 10. And and I just watched this Zoom. I was more of like a spectator, just there, sort of like organizing the discussion. And I noticed that, some people, for the most part, everyone's doing it with their clients, right? Some people, it's a federal law, they can file federally. Some people would want a pro hoc in if there was a referral from another attorney. Some people wouldn't want a pro hoc in. Some people charge X, some people charge Y. Um, some people say, I don't want any private loans. Some people are like, no, no, give me the private loans. Some people say, I want a minimum of 40,000. Some people a minimum of 20,000. It just really is all over the board. But I just realized that we have a handful of people and there's probably more. And if you're one of these lawyers that do this type of work, please let me know. Please set up a call with me so I can include you into this and understand. But there's ample amount of representation in the country that can process this type of attestation and student loan litigation and student loan discharge. But we just need a little more organized. And that's what I'm hoping to do here. The other thing I want to point out in NACPA in Colorado, they were adamant in saying this over and over in breakout after breakout after breakout. There's a fiduciary responsibility that bankruptcy attorneys have in bringing this type of thing up. Even if you don't want to do it, it's important to bring it up and lay it on the line. And then if you don't want to do it, great. We can refer it out accordingly, or you can do it in-house. So I want to point that out. That's a NACPA talking point, not mine. As bankruptcy attorneys, you owe it to your clients to bring up what's being done right now in the bankruptcy market. Right this minute, people are getting their student loans discharged through bankruptcy. If you want to do it, great. And if you don't want to do it, we have an option. And I want to prove out this option with you. This conversation we're creating, the call I did with Ed Bolts and those other attorneys happened a couple months ago. And I built out this system so we can prove it over the next 100 plate cases, and then we can finalize it, hopefully by the end of the year, and dial it in. But there's two paths to student loans for everyone on the call or everyone listening to this video. Number one, you do it yourself, right? It's pretty straightforward. There's plenty of training on there. Stretto offers tons of training on that. They have a software that will actually put the information in. It spits out a result if it's dischargeable or not. Josh Cohen has training with Student Loan Lawyer that you can get trained on how to do it. We're going to be releasing a video shortly with Tara Salinas, one of the board members from NACPA, talking about how what she uses AI in identifying if it fits the criteria with the prompt that she's personally developed because she does it with her own clients. So there's a lot of things you can do around that. A lot of videos on our 720 System Strategies YouTube page for training. And of course, if you have questions, book a call with me and we can just walk through it. Like, because there's a lot of other missing parts and sometimes it's easier to just have a conversation and say, well, what about X, Y, and Z, as opposed to piecing it all together with various videos and stuff. But what if you don't want to do it? What if you are sort of like an overwhelm and you're like, I'm busy with this, with bankruptcy, and I want to move on and I don't want to focus on student loans whatsoever. So this is what we've created. As many of you know, we amalgamate bankruptcy debtors from a lot of different places, right? We have paid influencers that are out there talking about us on Instagram, TikTok, and Facebook about what we're doing and what's working and what's not working, and they direct their calls to us. We have Facebook groups with 20,000 people in it. It's called Bankruptcy Support USA. And it gets people talking about bankruptcy. And if they need a bankruptcy attorney, we refer them. But when we get people that have questions regarding student loans, what we're doing is we're setting an appointment on our call. So, for example, this is the Bankruptcy Explained sort of like link tree. They can talk to a bankruptcy attorney. They can do various things. But one of them, as you can see here, wipe out student loans. And when they open up the wipeout student loans, it's a student loan assessment by phone. So this would be for a debtor, or more importantly, for a debtor attorney to refer your clients after they discharge a case. And you can pick a time. And when they come in, it's a basic, simple form. But this is really important. How do you hear about us? You know, Leonard Boyer or whomever it is, right? Like whoever your name is, this is where this would go so we can tag it appropriately, right? And the goal of this is we want to track where everything comes because we want to pay the debtor attorney. So if you do it in-house, great. You get paid and you're going to be very profitable with it if you do it the right way, according to the attorneys I know who actually do this. But there's a lot of you just like set and forget it, not interested. I want to focus on bankruptcy, and that's okay too. And that's what we want to do. The fee sharing on this, I mean, obviously attorney to attorney, we have nothing to do with it. When the lead comes in, we are having a 5 to 10, 15-minute conversation with them internally. Tell us about your situation. How long have you paid on your student loan debt? How much public student loan debt? And the questions that we are being asked to ask by our debtor attorneys that actually do the attestation. And then based on the criteria that we get for that individual debtor, their location, all that stuff, we transfer it to an attorney, set an appointment. And that's when it's logged from you. When we set that appointment with that attorney, we're logging you as the referring attorney, which is how you're going to get paid. And the referral fees, I'm assuming they're going to be somewhere between $250 to $500. But at this point, I'm just being fully transparent on what's happening. The system is built, but we don't have enough paying clients in the system to know exact numbers. And the reason why we don't is because obviously who pays, what's successful. There's across the board, people are offering money back guarantees. If they file the attestation, it doesn't work. There's a lot of things we're working on. But everyone who logs their clients from here on out is going to get paid on successful cases. And what we really need, I'm guessing, is around 100 successful cases to figure out. And then we're gonna make it all retroactive based on that. And that's what's happening. That's what we're happening. That's what we built at this point. I want to open up to the floor, questions, thoughts, anything like that. For those of you that are my clients, you know, I welcome feedback. I'm not offended. Like I'm better because of the feedback I get. Please open it up and we'll go from there. Show your video and ask your questions.
We get pretty good dollar in the East Coast. I was thinking about charging about 5,000 for a bankruptcy adversary proceeding, plus the filing fee, and then 500 an hour.
Okay. And what's your question? Well, like what's my take on that, or what's your question on that?
What do you feel people are charging in general, and
Right.
is there any regulations you know of that dictate how much can be charged?
No, it's all across the board right now. I mean, there's attorneys charging $3,000, attorneys charging $7,000. They change on the complexity. Private loans are a little different. There's a no-look fee in California for an adversary, but it's really, really up to the debtor attorney at this point. But I would make it simple, Leonard. That's the thing. I would avoid anything like $5,000 plus the hourly plus this. You want to make it really simple. And it's like, here's what I charge. I charge $5,000, or even better, break it down to the payments. I charge X number of dollars a month for X number of months. Boom. And then highly recommend money back guarantee. If we do not get your student loan discharged, or it we would drop the fee according to what your discharge was. So if you have $100,000 in student loans and we only discharge $50,000 of it, we drop your fee 50%.
Yeah, I don't know if in Jersey we'd be allowed to offer any kind of money back guarantees or anything like that.
So
And I
I'm
personally, I
not a
wouldn't
lawyer.
be,
Obviously, I'm not a lawyer. I'm a
right,
marketing guy. I'm just telling you what you don't want to do.
right.
You don't want to. I find that a lot of times attorneys are their own anti-sales committee. We want to make it easy for the person
Right.
to say yes and go
Okay.
from there. Thank you, Leonard.
Thanks, Bill.
Good deal. What else? Other questions?
I'm not a fan of doing adversaries myself
Mhm.
for a number of reasons. So if I have a stay of violation, I'll often refer it out to somebody else.
Okay.
I think what I'm hearing from you is I've got somebody who has a student loan. They want to get it evaluated, turn it over, whether in a Chapter 7 context, which I guess would be the general time,
Right.
uh, so that you can evaluate it and say, look, I'll take on this case
Yep.
or not. If you do take it on, you'd be filing an adversary in our district, Southern District of Texas,
Mhm.
and you'd want to appear pro hoc vice, I assume.
Yeah, the good point. You're right. I didn't clarify that in the call. You're right. Depending on the attorney that's referred to, many attorneys would be licensed in Texas, but in your case, let's just pretend the attorney is not. They would need to be pro hoc. If not, they would not need to be pro hoc.
So, in a 7, I don't think we need an application to employ. If it were a 13, we would. I said, well, yeah, we have to do our disclosures of compensation. Um, but I don't see anything wrong with you just coming in and taking it over if you decide to do it.
Mhm.
I'm just kind of thinking out loud.
Talking out
I,
loud.
I,
Right.
I kind of came into this a little cold as to what you were doing,
Yeah, no
but you
problem.
guys are really ready to do 100 cases or so to see how it goes and
Oh,
set
yeah.
up your schedule and how it
Oh, I mean,
works.
we're not, just so you know, Ken, we're not a law firm. I just know a lot of law firms and I think in terms of processes, right?
Okay,
So I'm connecting, I'm connecting the blocks. That's
all
what I
right,
want to do. That's my
I got you.
job. And if there's any attorneys on the phone, I see you're actually on. If you want to jump in and answer these legal questions or anyone, I'm open to it. But yeah, so Ken, what I'm doing is I'm just a marketing guy connecting blocks because I got to serve the client. And the bottom line is we have people right now contacting us via YouTube saying, how do I solve this problem? How do I talk to an attorney? And I just need to solve this problem. So, but yeah, definitely. I'm glad we connected. And I'm glad you're on the call, Ken. And for the most part, from what I gather, this is a chapter 7 conversation, right? Like,
Right.
there's so much low hanging fruit here. We don't have to fight hard to find a case. You guys all had one of these cases past your desk in the last 72 hours, right? And yes, we find the low-hanging fruit and you clarify with the debtor that yes, it's possible. Let's have a conversation about it. And then once the chapter 7's done, then we go from there.
You're making these deals outside bankruptcy?
Oh no, the case would be reopened if it was closed. Yeah,
Okay.
it's all in the bankruptcy court.
Okay.
Yeah.
Do you do anything in Chapter 13s?
That's a legal question that I'm not the guy to ask
Okay.
for that. Does anybody know that? Can anybody jump in here? Tyrus? Great.
Yes, you can do it. 13. For obvious reasons, some of them may be tougher if they have large amounts of disposable income. But if their disposable income is less than what it takes to repay the loans, they can still qualify for it. Or if the client's only filing a 13 because of a foreclosure or something where they don't have that disposable income, there's still a lot of possibilities there.
I would add that if somebody has too much equity and is in 100% plan, they're not going to qualify.
Yeah, no issue there.
So,
Of
right.
course, in Texas, we have practically unlimited home equity, so we're not worried about that. I don't see that many 100% plans.
The one thing I just want to emphasize here to everybody listening is that we don't have to fight to find the deals. Like we don't have to like pass on the marginal. There's plenty of good ones. There's plenty of good ones. And let's just let's take the low-hanging fruit first because it's just there's plenty of them.
Gotcha.
Igor, jump on in. Igor from Strato.
Yeah,
What
if
would
I
you
could
like to
just
say, Igor?
yeah, I'd just like to point out, I encourage everyone to go and download a copy of the Department of Justice guidance. It's on their website and take a read through it because I think there are some things that attorneys sort of take as a given, which may not really comply with how the guidance actually works. Like, for example, you guys are talking about equity. There's a section in the guidance which, pretty much says that they're not expecting the debtor to liquidate all their assets. That doesn't mean that there may not be circumstances where if they have a whole lot of assets, your AUSA is going to question it. But just I encourage you to read what the guidance says because I think some of the rules of the game that we think we know aren't really there. And more attorneys should go and read through it because it'll answer some of those questions. Like, for example, some of the expenses may get grossed up, right? So, well, there's a whole category of expenses under the guidance that your client's actual expenses could be $100, for example, but they'll get credit for $250 because under the guidance, they're going to be able to get the value of what the IRS standards are. So you just got to take a look and read through it because I think it may shift your perspective on how you think this used to work. I'm helping an attorney now, for example, he's dealing with an AUSA who's reviewing his request for discharge, and they're talking. The AUSA is looking at the federal poverty line, and his response is, "What are you talking about the federal poverty line? The guidance talks about the IRS standards, right?" And so even some of the AUSAs may need a little bit of education. So I encourage you to get really familiar with the DOJ guidance because it will help you better understand how this process works because it is very different from anything that it was in the past. We've gone from a system where was almost like a purely subjective review of whether or not you have the present ability to pay and the future ability to pay. And now the present ability to pay is essentially a math test. Don't you agree, Phil? I mean, it's basically like you look at the income, you look at the expenses, they're telling you what numbers to pick out of the schedules, and you compare them. Simple, yeah. Right? And on the future stuff, they're not even looking so much as to certain expenses. They're looking at factors that either exist or don't exist, like the age of the client, the age of the loans, right? So I encourage you to take a look at the DOJ, get real familiar with it, and understand that it's not your typical discharge proceeding that you used to do pre-guidance. It is a completely different ballgame. And Jason Giuliano just recently published a law article in the New York Times, quoted him, 87% success rate on these things, right? That's
It's
unheard of compared to what we used to do, right? So just want to encourage your audience.
Igor, I'm glad you brought that up. And Ken, we're going to include on the link when we send this out on the YouTube video, DOJ guidelines and the article from the New York Times, because that's an important aspect. It's extraordinary what's possible and what's being done right now. But the question is, do you want to learn it and you want to go through it? I mean, I'm advocating for all attorneys to do that. I've been talking about that for years, but the practicality of it.
They have these at the CLEs, and most bankruptcy attorneys take their break when they talk about student loans.
Oh, I know. I've lived it. I've lived the conversation. Thank you, Ken. I'm glad to have you on the call.
Well, I'm glad to be here. It's educational, and I guess it's time to deal with that issue, particularly since we got to include the student loans in our Chapter 13 payments now too.
Richard, how you doing?
Yay, Phil.
Good to see you.
What's the deal on the private student loans? I mean,
well,
like there's something harder about them. I mean,
oh no, we have
guidelines.
We have attorneys that love private student loans, and I have, for whatever reason, attorneys that don't like private student loans. Great, Ken. Glad you're here. Ken Neely, who I was referencing early on, he's very pro private student loan negotiation. Ken, take it away.
They're either the best cases or they're the worst cases. And let me explain. So I've had private student loan cases where I've filed the complaint and I got a call 3 days later asking for a stipulation to full discharge. I did an hour of work, just $6,000 or $7,000. I've had others that go all the way 18 months of grind it out, scorched earth, burn the towers type litigation, right? And so it's they're the best or the worst. But a lot of them, I will say, a lot of them are pretty easy to negotiate, particularly you start to learn the lenders that have pretty reasonable standards for at least partial discharge. It's very common with the Navient student loans to see them just reduce principal by maybe 50% and take interest down to zero. So if it's rare to see full discharges on private. I don't ever promise full discharges, no matter what the circumstances are, because it's rare to see full discharges, but it is very common to get really good deals that are no-brainer type settlement deals with most of the lenders. But again, some are just going to fight. They're going to go old school like they have for the last 25, 35 years and just fight to the death.
Richard, to answer your question.
Well, yeah, it's pretty much, but use the same format as you would for the federal loans, right?
Yeah.
Yeah.
Yeah, and a lot of times we'll do two cases, right? We'll file a federal discharge and we'll file private for the same client. And I just did this yesterday. In fact, we had this particular client had two private loans and one federal. And so we prepared the attestation, and as soon as we heard from the private lenders, attorneys for private lenders, I said, "Do you want the attestation and all the documents that we're going to send to the Department of Justice? Because that's a good starting point for, you can decide if you want more discovery after that or if you're willing to negotiate a settlement once you see that." Of course, Mr. Neely, send it on over. And a lot of times that will lead to just a settlement, a reasonable settlement offer right out of the gate. So,
Does
yeah.
anyone have a student loan, separate student loan retainer that they could share that we could use as a model?
I don't have one. Do you have a whole nother retainer, Ken? You do?
Yeah.
Okay.
Yeah,
Okay.
I can provide either terms of like pieces of it or even the whole thing. I'll look at it, see if there's really anything in there that's proprietary.
Just
But
send me whatever you think, Ken,
yeah,
appropriately, and I'll put it in the email and the thing. Hey, Ken,
Thanks.
let's chat. Igor bring up the USAs, right? And we talked a lot about the breakdown of that, right? Specifically how some AUSAs get it and some don't, right? Where do you go with that? Can you speak into that a little bit?
yeah, it's like 85-20, 85-15, that get it versus the ones that just want to add their own wrinkle, their own interpretation, be difficult for no reason.
That's a lot
And
higher than it used to be.
yeah, yeah, I
Yeah,
think
so
they're
it's moving.
I think they're figuring it out. I think they are very overwhelmed with the reduction in staff sizes at the Department of Education and the Department of Justice. So these are taking a long time, not because of negligence, but just because of staff shortages. But I think they're figuring it out. I think that for the most part, the Department of Justice is wanting to get these recommended for discharge. But you do have a few rogue AUSAs that are difficult. It's not really consistent, and I think whenever there's a survey on this, I think NACPA's done a survey, and maybe even NCLC, other consumer organizations, NACA maybe. And the number one complaint is just the consistency and predictability. It is just a little bit tough. So that's where consumer bankruptcy attorneys, I think, kind of they're like, I'm used to knowing if I fill out the schedules and statements correctly and I analyze that and I look for non-exempt assets and transfers and there aren't any,
Mhm.
that I'm pretty comfortable it's going to just go right through. I'm not going to have any hard conversations with my client. You are going to have some hard conversations if you do this work because sometimes it looks like a good case. You just get an AUSA that says, no, I'm not doing it,
Yeah.
and you have to figure out what to do. But it's real lawyering. It's good. It's like you get to advocate, you get to really argue, you get to go through the facts, and you get to figure out ways to like present this in a way that's most favorable to your client. And like really, your advocacy makes a massive difference. Not that you have to know anything special, just you have to be passionate about going to that AUSA and saying, this client deserves a discharge. I've done a lot of bankruptcies in my life. This client has undue hardship. Let me show you why. Let me prove it. Don't accept a no for an answer. Go back and say, why? Look at this, look at that. they had to drop out of school, they had to, whatever other facts you can bring up. And it's rewarding work because it's, it's you get to use your skills.
I think you just summarized why a lot of debtor attorneys shy away. Not that they want to advocate for the bankruptcy, their debtor. Obviously, we're in this business of advocating, right? But it's just a different energy when
Yeah.
you have someone that's like, no, I'm not talking about it. It's like we don't deal like well, you guys don't deal with that like with trustees. Like we're all on the same team. How many cases have you had either a full discharge, partial discharge? Where are you at right now?
Oh, I would say that 87% number, first of all, to give you percentages, is pretty close to what we've seen.
Mhm.
So if you are careful about the cases you accept, you will see a 90% success rate. So I don't mean to be discouraging by saying there are some AUSAs that just won't work with you. It generally where we've had to back out of a case, it's because the client misrepresented maybe income
Mhm.
or the circumstances just changed dramatically. That has happened too. But on sheer numbers, like hundreds that we've discharged, probably 200, and we have 100 pending right now. The challenge has not been getting the cases, as Phil said. There are people like 5 a day contacting us, begging us to take their case. The challenge has been figuring out how to charge for it and make sure we make money so it's profitable and have the people that can work on it. Like have a dedicated attorney, a dedicated paralegal that loves the work, is good at the work, sticks with the work, stays around. Those have been my firm's challenges with it, is just, getting the work done. So
Ken, I appreciate you as always, always. We're making a lot of progress across the board on other things. Next month, we're going to be talking about lead follow-up. Over the past 10 years, we've sent tens of millions of emails, and I've amalgamated what I've learned over the past 10 years. And we have shifted our follow-up sequence started with email only for like 6 months, and now it's 4 years, text, email. We've set hundreds and hundreds and hundreds of thousands of appointments for debtor attorneys. Like the data is so overwhelming. Next month, we're going to talk about that. Just like what I've learned. And whether you want to do it yourself or you want to use it with us, that's great. If anyone is interested in talking about anything we're talking about, I'm going to put this link um, in the in the in the chat. Here's my link to talk to me about anything. I've also included the link to refer. Please make sure if you do refer and it's not something and you want to refer out to one of these attorneys that are going to take your case, please, please, please mark your name so it can be logged and you can be paid in the future. And I'm just grateful for the activity. I'm grateful for the people that speak up. I'm grateful for the people that join. And we're going to continue to solve problems for debtors. We're going to continue to solve problems for our debtor attorneys and make things better all over. If you're not going to be at NACBA, if you are, we'll see you at NACBA in Boston. If you haven't decided to go, I highly recommend you go because you will always get more out of it than you expect. Okay, everybody, thanks for your time. Talk to you soon. Bye-bye.
To book a free strategy session for your bankruptcy firm with 720 System Strategies founder, Philip Terone, see the link in the description.